sneaky like. So DeRogie. All right. All right. This case is one where we call it, colloquially, we call it a rocket docket case. It's one that Ms. DeRogie, I think, has spoken to an attorney from district court that she had in district court. So, ma'am, this involves entering a plea of guilty. Are you prepared to go forward with that here today? All right. Would you raise your right hand for me? Do you swear to tell me the truth? So help you God. All right. Thank you. So, ma'am, you know, there's a couple of different things here that I have been handed, and it's kind of interesting. I think I have 3 copies of everything somehow. Most of the time you don't have everything you need. I think I got 3 copies of everything. Will you, I know you can't see from where you are, but the first document I want to talk to you about is this motion to enter a guilty plea, and it's got your name on it. It says that you spoke to Mr. Austin, and he talked to you about that motion and what it contained and what you would be signing and all that. Do you remember that?
Yeah.
Okay. And do you feel like you had all the time you needed to discuss that with him?
Yeah.
All right. The next thing would be the Commonwealth's offer on a plea of guilty, and that's right down here. That document also sets out your charges, which in this instance is 1 count of possession of a controlled substance, first degree, first offense, 1 count of possession of drug paraphernalia. Those are respectively a D felony and an A misdemeanor, and it shows where the Commonwealth has made a recommendation of how they wanted to proceed if you pled guilty. Did you go over that with him as well? All right. And then last but not least, there is a pretrial diversion order, which was what the Commonwealth was agreeing to recommend, was that you go on pretrial diversion. And this order sets that out and discusses that you would be on pretrial diversion for a period of 2 years, follow the conditions of your pretrial diversion. And if at the conclusion of that period, you do not have any violations pending or motions to void your pretrial diversion pending, then your charges would be dismissed. Do you understand that? Okay. So let me ask you, first off, do you realize that any agreement of this type, it has to be entered into by you voluntarily? In other words, it's not something that I'm going to, do or make you do, or nor is anyone else. Do you understand that? Okay. If you do plead guilty, then you are waiving your right to not to incriminate yourself. You're waiving your right to have a jury trial where the Commonwealth has to prove guilt beyond a reasonable doubt. You're waiving your right to confront and cross-examine the people that give evidence against you. You're waiving your right to put evidence on in your defense, and you're waiving your right to appeal. Do you understand that? All right. Do you feel like you're under the influence of anything today? Do you feel like your judgment is impaired for any reason today? All right. So as I mentioned to you before, your first charge is possession of a controlled substance, first degree, first offense. The Commonwealth agrees to recommend a sentence of 1 year on a guilty plea to that. Possession of drug paraphernalia is a misdemeanor. The Commonwealth agrees to recommend 12 months on a guilty plea to that. Those would run concurrently or at the same time for a total recommended sentence of 1 year plus a possible fine and court costs, which would be at the court's discretion. You also, a condition is also that instead of being sentenced to serve 1 year, you would go on pretrial diversion with the condition that you enter and complete the U-turn program. And if you complete that program prior to the expiration of 2 years, which you probably would, that you would be supervised by probation and parole for the rest of your 2-year period. Is this consistent with what you thought you were agreeing to? All right. Other than what I just told you, has anyone promised you anything to try to get a plea of guilty out of you? All right. Has anybody threatened you to try to make you plead guilty? Are you pleading guilty voluntarily today? Do you tell me that you acknowledge on October 13th, 2020 in Barron County, Kentucky, you knowingly and unlawfully possessed methamphetamine and drug paraphernalia? Okay. Then, ma'am, I believe that I am in a position here where I can accept your plea of guilty as having been entered freely, knowingly, intelligently, and voluntarily. Okay. Let me ask you a couple of real quick questions just to be sure that we've got everything the way we need it. My first question would be, can you tell me what your address would be if I was sending you a letter right now? 1151 Coomer Road, and that's Edmonton. All right, thank you. And here's what we'll do. I'm going to order you as part of your pretrial diversion, of course, to report to U-Turn for monitoring. I'm going to order you to pay court costs, which is $165. I'll give you 6 months to pay that. I'm waiving, there's a deferral fee, but I'm waiving that so you don't owe that money. And I'm not going to fine you, okay? All right. So the other thing that we need to talk about is going to the U-Turn office. Have you been there yet?
Yes, I know where it's at now.
Okay. So when I finish up here with you, you can report over there. I mean, I don't know that I'm going to tell you have to go right now, although since you're up here and you don't live here, it might be a good idea to go ahead and go. But I mean, I'm going to give you till tomorrow to go if you got something else to do. You also have a probation officer, a couple of probation officers sitting right behind you, and they are going to need to also meet with you to get this ball rolling. So talk to them when I get finished talking to you, and they'll tell you what they need you to do and when they need you to do it. So just do what they're telling you, and then go see the U-Turn folks, and everything ought to be okay. Do you have any questions? Okay. All right. So if you'll talk to Officer Coates right there, and then when she's done with you, go on over to U-Turn. Okay. Thank you. Kiara Horton. You're Miss Horton? Okay, Miss Horton, will you raise your right hand, please? Do you swear or affirm that you'll tell me the truth, so help you God?
Yeah.
All right, thank you. Miss Horton, a few things here you and I should be discussing. One of them is that there is a motion to enter a guilty plea. I don't know how well you can see from way back there, but does that look familiar to you? All right. And over here on the second page, there is a signature, and it's not your actual signature, it's a virtual signature. But did you talk to your attorney about that?
Yeah,
All right, you gave him authorization to do that. Very good. The next question I want to ask you about real quick is this document here, which is the offer, Commonwealth's offer on a plea of guilty. And it also appears to have been virtually signed by you. Did you give your attorney authority to do that as well? All right. Now, did he thoroughly discuss these documents with you? All right. Go over them with you, explain them to you, et cetera? All right. Are you comfortable that you understand what you have signed? All right. Do you understand that this involves a plea of guilty and nobody can force you to plead guilty? In other words, you have to be the one that makes that decision. Okay. Do you feel like you are being forced by me or anyone else to plead guilty?
Yeah.
All right. Do you also understand that if you plead guilty, you waive the following rights? You waive the right not to incriminate yourself. You waive the right to have a trial by jury where the Commonwealth is responsible for proving guilt beyond a reasonable doubt. You waive the right to confront and cross-examine the people that give testimony against you. You waive the right to put evidence on in your defense, and you waive the right to appeal. Do you understand all those things? All right. Do you feel like you're under the influence of anything today? Do you feel like your judgment is impaired for any reason today? The offer from the Commonwealth is as follows. Count one, possession of a controlled substance, first degree, first offense. That is a Class D felony. On a plea of guilty, the Commonwealth recommends a 1-year sentence. Count two, possession, controlled substance, third degree. That is an A misdemeanor. On a plea of guilty, the Commonwealth recommends a 12-month sentence. Count three, drug paraphernalia, an A misdemeanor. The Commonwealth recommends a 12-month sentence. All of those sentences would run concurrently for a total recommended sentence of 1 year. The Commonwealth agrees, rather than to sentence you to serve that 1 year, that we would place this case on pretrial diversion for a period of 2 years on condition that you complete the U-turn supervision program, and that if you complete that within the 2 years, you are then going to be supervised by probation and parole. If at the conclusion of 2 years, you don't have any motions to revoke your diversion pending or any warrants pending, then your pretrial diversion is over and your charges get dismissed. Okay, is that how you had it explained to you pretty much?
Yeah.
All right. Is that what you thought you were agreeing to?
Yeah.
Other than that, has anybody promised you anything to get you to plead guilty? Has anybody threatened you to try to make you plead guilty? Are you in fact telling me voluntarily and of your own free will you are pleading guilty?
Yeah.
Okay. Are you acknowledging to me that on or about July 30th, 2020 in Barron County, Kentucky, you knowingly and unlawfully possessed methamphetamine, alprazolam, and drug paraphernalia? Okay. Then I will accept your plea of guilty to those charges. I'm going to turn my attention to this order of pretrial diversion. It looks like you have signed it as well. The only thing that needs to be filled in rather, is you have court costs of $165, which you have 6 months to pay. So, I'll give you it's basically the end of the year to pay that. Deferral fee I'm waiving, and the fine I'm not going to impose at this stage. Can you tell me what your address is? 2633. Thank you. All right. So, Ms. Horton, I'm going to get all of this stuff prepared and entered for you. In the meantime, what I need you to do is, do you know where the U-turn place is? All right. So I need for you to go over there after you leave here, okay? Before you get out of here, though, I need you to talk to one of my probation officers right behind you, and they're going to tell you what they need you to do. They're just going to, have you come in and fill out some paperwork and that kind of thing. So just kind of show up when and where they tell you and do what they tell you. You'll be good to go. Then head over there and see Miss Adkins or whoever's in the office, okay? Do you have any questions? All right, thank you. Folks, let me just point out that our mask rule necessarily implies that we're wearing our mask the way we're supposed to wear it. So I'd like for everybody to be doing that before I look up and have to get on anybody. Yeah, I was there. A bunch of people popped up to come in the meeting and I was letting them in. We might as well try to do this. Cornel, oh, she's in jail. Yeah. Holden Piercy. He's on here.
Yes,
Holden
sir.
Piercy. Yeah, he's on here.
I'm getting my video started here.
Yeah. All right, Mr. Piercy. How are you?
Good, you?
I'm doing all right. All right, will you raise your right hand for me?
Yes, sir.
You swear or affirm that you'll tell me the truth, so help you God.
Yes, sir.
All right, thank you. Mr. Piercy, I've got some things I need to talk to you about, okay?
Okay.
And want to make sure you can see them, so I've zoomed you and me both in on this thing so that we can see each other.
Okay.
All right. This document here is motion to enter a guilty plea. Does that look familiar to you?
Yes.
All right. And on the second page there is a signature page, which is not really a signature, it's virtual signature, right?
Yes.
I mean, you didn't actually sign that because I bet your writing's not that good.
No, it's not.
Yeah. This is the Commonwealth's plea offer. Does that look
Yes.
familiar to you?
Yes,
All right.
it does.
And again, it's got a virtual signature on it
Yes.
right here. Did you authorize your attorney, after you look these things over and discuss them with your lawyer, did you authorize him to, or her, to put your signature on there?
Yes.
Okay. Are you confident that you understand these documents that you have signed?
Yes.
All right. Mr. Piercy, do you understand that nobody can make you plead guilty? So if you enter a guilty plea, that has to be a decision that you come to on your own, right?
Yes.
Do you feel like anybody's made you plead guilty today?
No, sir.
Okay. Do you understand that if you plead guilty, you waive your right not to incriminate yourself?
Yes, sir.
You waive your right to a jury trial where the Commonwealth has the burden of proving guilt beyond a reasonable doubt.
Yes, sir.
You waive the right to confront and cross-examine witnesses and to put evidence on in your defense.
Yes.
Okay. And do you understand that you waive the right to appeal?
Yes, sir.
All right. Thank you. Mr. Piercy, do you feel like you're under the influence of
No, sir.
anything? All right, sir. In your case, the Commonwealth has agreed to the following. On a plea of guilty to possession of a controlled substance, first degree, first offense, a Class D felony, the Commonwealth would recommend a sentence of 1 year. On a plea of guilty to possession of drug paraphernalia, a Class A misdemeanor, the Commonwealth would recommend a sentence of 12 months. On a plea of guilty to theft by unlawful taking, under 500, the Commonwealth would recommend 12 months. On a plea of guilty to possession of marijuana, a B misdemeanor, the Commonwealth would recommend 45 days. All of those recommended sentences would run concurrently with one another for the total sentence of 1 year. The Commonwealth would agree, rather than to sentence you to 1 year, for us to do pretrial diversion under supervision of the drug court program. Do you understand that?
Yes, sir.
And if at the conclusion of your diversionary period or upon the successful completion of drug court, there are no motions pending to revoke your or void your pretrial diversion, and there are no warrants pending against you for your pretrial diversion, then your charges would actually be dismissed. Do you understand that?
Yes, sir.
All right. And is that pretty much how it was explained to you?
Yes.
Other than that, has anybody promised you anything to try to get you to plead guilty?
No.
Has anyone threatened you to try to make you plead guilty against your will?
No, except for my
Okay.
wife.
All right. Yeah, she doesn't count.
Right.
So my question then is, are you acknowledging to me voluntarily and of your own free will that on March the 6th, 2021 in this county, you knowingly and unlawfully possessed a Schedule II controlled substance, which was oxycodone,
Yes, sir.
and you knowingly and unlawfully possessed drug paraphernalia and marijuana?
Yes, sir.
And finally, are you acknowledging that at that same time and place, you unlawfully took or exercised fiscal control over property belonging to Walmart valued at less than $500, having the intent to deprive the store of the property?
Yes, sir.
All right, Mr. Piercy, I am going to accept your plea of guilty here today. And do we have instructions to tell him about reporting? You do? Tomorrow? Call?
In person.
In person. All right. You know where the drug court office is?
No, I don't.
All right. Well, it's up here on the south side of the square, which I don't know if you're bad with directions or not, but you know, it's on the, it's back in the back of the courthouse and it's on the square. You won't have any trouble finding it if you can figure out where south is. But in the meantime, I'm going to need to get a phone number from you because the ladies over here with probation are going to need to give you a call and talk with you to get some information from you. Okay. So can you fire off your phone number for me?
270-590-6379.
Did you all get that?
Yes, sir. Thank you.
Super. So they're going to call you maybe as soon as today
Okay.
to ask you some questions. Okay.
Okay.
And they're legit questions. So just answer them.
Okay.
They're not being nosy. All right.
All right.
All right. And then report tomorrow by 10 o'clock to the drug court office and do what they tell you and everything ought to work out.
Okay.
Do you have any questions?
No, sir.
Okay. Good talking to you. You're free to go.
All right. Thank you.
You bet. Cayenne Allenspach. Might be just worth pulling the plug on that one. Yeah. We've tried about 100 times. Linda Thomas. It hadn't been 100 times. It's been 3 times, but it's felt like 100 times. How are you? I am fine. You are Linda Thomas? Okay. Will you raise your right hand for me? Do you swear or affirm that you'll tell me the truth so help you God? Okay. Can you tell me your address?
3238 Eagle Road, Oscar, Kentucky.
3238 Etoll Road. Let's go, Kentucky. All right. Can you tell me your date of birth?
June 14th, 95.
Just a second here to track it down. All right. Ms. Thomas, I know you can't see from that. Well, maybe you can. You could have really good eyes. But this is a document that's called a motion to enter a guilty plea. It looks like it's got a, kind of a virtual signature on it. It's not really your actual signature. But did you go over that with your attorney and talk with her about it and discuss it? Okay. Do you feel comfortable that you understand it?
Yes, sir.
Okay, very good. You also have an offer from the Commonwealth, which is on a sheet that looks like this right here. And it's got a signature page on the back as well. Same kind of signature, not a real one, but a virtual one. Did you authorize your attorney to put your signature on that document too? And did you only do that after making sure that you understood it? All right, so let's go back through these kind of one at a time. Do you understand that nobody can make you plead guilty and that if you do plead guilty, that has to be voluntary on your part? Okay. Do you understand that you have the right not to incriminate yourself? And if you plead guilty, you waive that right. Okay. Do you understand that you have the right to to have a trial by jury where the Commonwealth would have to prove guilt beyond a reasonable doubt? And you waive that if you plead guilty. Okay. You have the right to confront and cross-examine the people that give testimony against you and to put evidence on in your own defense. If you plead guilty, you waive each of those rights. Okay. And finally, you waive the right to appeal if you plead guilty. Do you understand? Okay. Now, Ms. Thomas, do you feel like you're under the influence of anything today? Your judgment impaired for any reason today? All right. The Commonwealth has made the following offer to you. If you plead guilty to count 1, possession of a controlled substance in the first degree, that is a Class D felony. The Commonwealth would recommend a 1-year sentence. If you plead guilty to count 2, tampering with physical evidence, that is a Class D felony. The Commonwealth would recommend a 1-year sentence. If you plead guilty to count 3, drug paraphernalia, that is a misdemeanor. the Commonwealth would recommend a 12-month sentence. If you plead guilty to possession of a controlled substance in the third degree, another A misdemeanor, the Commonwealth would recommend a 12-month sentence. The 1 year, the 1 year, the 12 months, the 12 months, they all run concurrently so that the total sentence recommendation is 1 year. The Commonwealth would agree not to sentence you to serve 1 year, but instead to place you on pretrial diversion under supervision of the drug court program. And once you complete your pretrial diversion, if you successfully do so, then your charges get dismissed. Do you understand that? Okay. And is that essentially how it was explained to you when you agreed to it? Other than that, has anyone promised you anything to try to get you to plead guilty against your will? Has anyone threatened you to try to get you to plead guilty? All right. Are you pleading guilty voluntarily today? Are you acknowledging to me that on January 30th, 2021 in Berrien County, you knowingly and unlawfully possessed methamphetamine, drug paraphernalia, and gabapentin? Are you also acknowledging that at that same time and place, you committed the offense of tampering with physical evidence when believing that an official proceeding was pending or going to be instituted? You destroyed physical evidence which you believed could have been used in the proceeding against you, and your intent was to impair the availability of the evidence so that it could not be used against you. Okay. Then I believe, Ms. Thomas, that we're going to be able to accept this plea of guilty and have you starting up in drug court tomorrow. 10 o'clock. So do you know where the office is?
Behind you.
There you go. Right out there. All right. So if you'll report by 10 o'clock in person, they'll get you started. Before you do that, I need for you to talk to one of these ladies behind you here with the probation office. They have some, statistical information they have to compile and so forth. So just kind of, they'll ask you some questions, answer their questions, kind of do what they tell you, and then they'll be done with you. And then you can go tomorrow to see Candy. Okay. Thank you. Yep. Huh? No.
Britt Paxton.
Thank you. All right. Yes, sir.
Brian, I talked before we began, and I think he's requesting a pretrial conference in this case. I think it's coming in, come to his office a couple of times.
Yes.
Got a chance to go over the discovery.
So she's come in a couple of times to review some of the discovery, but not all of it. Also, there was an issue a few months back where I requested some medical records, and through looking at some family doctor records, I said maybe we'll find out the actual identity of the neurologist with whom she treated at Boulder Grade, which was Dr. Chow. We ordered the records around, I think, the 1st of March. The last time I checked, we had not received those. So I'm kind of waiting on those to see if the motion could be filed on her behalf on those.
Sure.
So I would request maybe another 30 days.
30, you say?
Yes, sir.
You want to look at June the 7th?
Yes, sir, Judge. That sounds good.
1 o'clock on June the 7th? Okay,
Yes, sir. And that was June the 7th?
7th, yes,
Okay, yes, sir. Thank you.
like a lucky number 7.
Like you said.
All right,
Yes, sir.
all right. Thank you. Hey, let's see, Mr. Poole, did I see you?
Yes, sir, Your Honor.
Yeah. Are you appearing for Mr. Kirby?
Yes, that's correct.
All right. I believe they got on here a minute ago, and I think that's the only individual I've got in that facility. So maybe we can go ahead and take that up if you're ready.
Sir, yes, sir.
Mr. Kirby, are you still there? There he is. Uh-huh. Yeah, I need to get them to unmute. He's muted.
Hello?
There you go.
Hey,
All right.
Please, the court.
Yeah, first off, first order of business, I think I had the DPA on this one, so I need to relieve the DPA out of this case.
Yes, sir. No, I just got hired over the weekend, so I owe you an entry of appearance on the case.
Okay. All right, sir. Go ahead.
Well, Judge, I think it's just on for a pretrial. Obviously, I'm just now getting into the case. I'll need a little bit of time to get discovery and I guess touch base with the Commonwealth to see where we're at and see what if anything can be done towards a resolution. I just asked the court to put it on for another pretrial conference. Mr. Kirby's serving on a state sentence. So I don't think there's any concern with rushing this through. I know it's been on the court's docket for a little while, but he's not going anywhere anytime real soon. If the court would just set this for a pre-trial conference, we'll try to move it forward.
Yeah. Do you have any proposed date? We can probably with it.
I don't. I'm not sure if how I'll need to get discovery if Mr. Berry can forward that, or if I need to get that from the Commonwealth. I guess I would defer to them as to their timeline.
How Mr. Berry, is that discovery that you can forward on to him, or does he need to? Mr. Berry got a lot of files over there, as you might imagine.
I can mail that to Mr. Poole if I can get a mailing address.
Sure. Probably the easiest way to get that to me would be the P.O. Box 1359. And that's in Bowling Green, 42101.
And I can get that out probably tomorrow.
Okay, that'd be great. And with that, Judge, I don't know, maybe about a month or so to give me time to digest that and to discuss that with my client.
Yeah, let's look at June the 14th. That'd be 6 weeks.
That should be fine, Judge. Will that be a morning or afternoon docket?
1 o'clock.
1 o'clock. And you guys are back in person, or?
I mean, we're doing some, in this situation, he's going to be in custody, and I don't know that it makes a lot of difference for you to drive over here as long as you get on one way or the other.
Okay.
If he could be here in person, I'd say yay, but it doesn't look likely. So he can just appear this way, and you can appear remotely if you want to.
That'd be great. All right.
All right.
That's all I have today, Your Honor. And if there's nothing more, may we be excused.
Yep.
can
Thank you.
I ask you something? Is there any way to get a bond unsecured, since I am serving a state sentence? It'll help bring my level down and maybe my parole eligibility. I don't know, but
What do you know what your eligibility is now?
it's July 1st, but I'm in SAP. So it would be parole upon, which would be September 23rd. And it may open up some avenues for us to resolve this matter. I don't know if that were to happen. I wouldn't be going anywhere anytime soon. I can tell you that.
Yeah. What do you think about that?
Bond's discretion of the court, but as far as this is Reese's case, so I'm sort of pitching for her while she eats lunch, but I don't see any major opposition to it.
Yeah.
I've always showed up to court, Your Honor.
Yeah. I think that's probably doable. Amy, is that something that can you hand me his file right real quick? Please. All right. Thank you.
Earliest was July.
Yeah, but I think he's got to finish this SAP. Is that what you were telling me? Mr. Kirby? He appears to be frozen in place.
Either that or he's sitting really still.
I would not want to play poker with that guy. Yeah. Believe that's what he said. So we'll just change that to 5,000 unsecured with the standard conditions.
Yes, sir.
All right.
And I'm sure he'll be calling me. I'll let him know.
Okay, thanks.
All right. Thank you, Your Honor. You guys have a good day and we'll see you in a few weeks.
All right. All right. Yes. Jonathan Bunch.
Just to inform that Mr. Garrett is stepping in for this case. I don't think he's discovered it.
Okay. All right, so taking the DPA out of this one. When do we want to do it?
If you want to set out maybe 45 days. Or 60.
June. There's going to be a bunch no matter when we do it. We can do June 28th if you want to. All right, Mr. Bunch, just stay in contact with your attorney, okay? Be sure that he can find you when he needs you. All right, thank you. Elijah Hun.
Judge, some months ago, I had filed a motion to revoke Mr. Hunt's bond due to a new charge involving the same victim in one of these felony cases. So I wanted to ask the court to set a hearing date on that. I think it got delayed due to a combination of COVID. And then I think he went to some sort of outpatient program shortly after I filed a motion. I'd like to set a hearing date.
Yeah. So do you want to set, there's been several things happen since you filed that motion. So let me go in here. So we haven't already had a hearing on that motion. Okay.
And he went into treatment for never was outpatient. And then also due to COVID, us going to just couldn't get put on.
Are you sure we didn't have a hearing? Because I think we had a hearing because on May the 19th, I entered an order and said on motion of the Commonwealth, the defendant's bond is revoked. He shall remain in custody until further orders of the court. And then that was later on down the road there, a month or two later is when I did the order to release him, reinstate his bond on condition that he enter and complete this treatment facility in Elizabethtown. what I'm trying to do is not question you. I just don't want us to get there and then nobody find a motion and we've done all this for nothing.
I could be wrong, Judge.
Looks like we had a hearing on May the 18th and Officer Phillips with the GPD testified about a new arrest that had occurred on 5/9/2020, charges of violating an EPO and 4th degree assault.
I guess that's what it was, Judge. I apologize. I was trying to go off my own memory.
It's been a long time. I mean, I wouldn't have remembered it except I just happened to have it in the file. I certainly didn't. But then in May, we revoked the bond. In July, I reinstated it and he went to treatment. And then I think in one of these files, I've got a letter that he went and enrolled, and they would tell us if he didn't finish it, and they never told us anything. So I assumed that meant he finished it.
I provided a copy of the certificate of completion to council, Your Honor.
Yeah. They're never as good about giving us those certificates from these places as they are about giving us the intake letters, but
We'll have to put it off anyway, Judge. I don't have a good number of the victim. I need to talk to the charges office.
oh yeah, I don't have any problem with putting it off at all. I just didn't want us to all get geared up for something that we've already done.
I'll let you know. I don't even remember it, but.
All right. So how far out do you want to go? Maybe,
We can go into the first or second, I think that's the second week of July. I don't want to keep calling on June 28th.
yeah. Well, so you're not going to be here the 12th.
Yeah, I'll be gone from the 11th through the 22nd
Or-
of July.
Yeah. So as far as Mondays, she'll be gone the 12th and the 19th. So we could put it on the 26th.
That's fine.
Okay.
I got other victims in other cases too.
All right, Mr. Hun, so this ought to give you plenty of time to talk to your attorney. I'm sure that she was not your attorney the last time I saw you, so you all got some catching up to do, right? Okay, July 26th at 1 o'clock. See you then.
Kenneth and Carolyn River.
Kenneth and Carolyn Vibbert. All right,
Wait here while I fetch my water.
Secondly, Judge, the Commonwealth is unopposed for removing the ankle bracelet.
I'm not aware of any violations. But I still would have to be subject to drug testing.
who has an ankle bracelet? Just him? They don't both have ankle bracelet. He's hitting his pretty good.
Might have a imaginary bracelet.
Judge, disregard the thing about that ankle bracelet. It doesn't apply.
Okay.
Judge, can we move that to the first Monday in June? I'm sorry.
June 7th.
Yes.
Okay. Got it done.
Thank you, Judge.
Thank you. What were we, does anybody remember what we were going to do with Mr. Pettigo? I remember he's at work. He's sitting there in the car.
Here I am.
We had him on last Monday and we said, let's put it over to this Monday, but I don't remember exactly what was in the works. Yes, sir.
Hello.
Hello, Jerry. Hold on.
Hey, how y'all doing?
We're doing the best. Oh, it looks like I got a motion in there, a guilty plea right here.
Yes, sir. Yes, sir.
I was just wanting to call that one because he was at work and he's out in the car. So if we could get him,
Yeah,
taken
yep.
care of, get him back to
Yep.
where he's earning money.
Boy, yeah, I appreciate that. I'm getting a customer right now. My boss is taking with me today.
Well,
But we're done here. We're fixing to leave here and go to another place.
you're going to get a cussing. I want it to be for something you did, not for something I did.
Yeah. Well, that's awful nice, baby.
All right. Are you ready to go?
Yes, sir. Yeah.
Raise your right hand for me, please.
I do.
Do you swear or affirm you'll tell me the truth, so help you God?
Yes, sir.
All
I
right,
do.
Jerry, can you see this?
Yes, sir.
Does that look familiar to you?
It does.
Is that your signature?
It is. Yes, sir.
Okay. Does this look familiar to you?
Yes, sir.
All right. And is that your signature?
It is.
Did you read over and discuss both of these things with your attorney before you signed them?
I did, Your Honor.
All right. Do you have any questions about what you have signed that you couldn't get answers from when you talked to your lawyer?
No, sir.
All right. Mr. Pettigo, do you understand that nobody can make you plead guilty, and if you plead guilty, that has to be your decision that you come to voluntarily? Oh, you put it on mute.
Oh,
All right. Do you understand that you have to come to that decision voluntarily?
yes, sir. I do.
All right. Do you feel like I or anyone else has made you decide to plead guilty?
No, sir.
Okay. You understand that if you plead guilty, you waive the right to remain silent or the right not to incriminate yourself.
Yes, sir. I do.
Do you understand that you waive the right to a trial by jury where the Commonwealth has to prove guilt beyond a reasonable doubt?
Yes, sir.
Do you understand that you waive the right to confront and cross-examine people that give evidence against you?
Yes, sir.
You waive the right to put evidence on in your own defense.
I do.
All right. And do you understand that you waive the right to appeal?
I do, Your Honor.
All right. Mr. Pettigo, do you feel like you're under the influence of anything today?
No, it's your way.
All right. Good deal.
Yep,
In this case, the Commonwealth has made the following offer. Count one, possession of a controlled substance, first degree, third or subsequent offense. The Commonwealth would recommend that is a Class D felony. The Commonwealth would recommend a 1-year sentence. Count two, possession of drug paraphernalia, a Class A misdemeanor. Commonwealth would recommend a 12-month sentence. Those two sentences would run concurrently for a total of 1 year. The Commonwealth would agree to supervise probation of that 1-year sentence for a period of 3 years. The 1 year in this case would be consecutive to any prior case. You understand everything that I've just said?
Yes, sir.
And is that your understanding of the agreement that you reached?
It is, Your Honor.
Did anybody offer you anything other than what you and I have just talked about to get you to plead guilty?
No, sir.
Did anybody threaten you to try to make you plead guilty?
No, sir.
Are you pleading guilty voluntarily?
I am, Your Honor.
Are you acknowledging to me that on July 21st, 2020 in Barron County, you knowingly and unlawfully possessed methamphetamine and drug paraphernalia?
Yes, sir.
All right, Jerry, let me ask you this question real quick. Are you on probation right now, or is it parole?
It's probation.
Probation.
Yes,
All
sir. I ain't never made pro.
on parole.
He's not on probation? They were back there nodding.
Oh, no, wait a minute. Wait, I'm on I got MRS.
MRS, right? Yeah.
Yeah.
So that's kind of a weird, it's basically
I still-
parole.
I still got probation officer though. I'm on a high risk. I still got to see him once a month and collar week.
All right. What I'm trying to do is y'all have anybody object real big if I just go ahead and sentence him and y'all tell Seth what happened and he just keeps his same report date? When are you supposed to see your officer again?
The 6th.
The 6th?
Yeah.
Yeah, that's Thursday.
Yes, it's Thursday. Yeah.
All right. So we're going to tell Officer Bennett about this thing here today, and then you
Okay.
just keep your next report date and go see him on the 6th, okay?
Okay. Yes, sir. I will.
All right. And if this is okay with you and save you another trip up to court, I'm going to go ahead and sentence you, and you'll get the 1 year, and it'll be consecutive. And I'll grant your request for probation. We'll probate that 1 year for 3 years. I'll waive your fine and costs. All right.
Thank you, Judge. Appreciate y'all.
Do you have any
Okay.
questions?
That'll be it.
All right.
Thank you. Thank
Be
you.
good. Okay.
Appreciate
See
it.
ya.
Thank you. Thank you, Jesus.
Lorenzo Martin. Thank you. You're like a mind reader. Except I said it out loud, so really, you're not a mind reader. You're just a voice hearer. Okay. What say ye about Mr. Martin?
Your Honor, Mr. Martin had actually completed life skills on. I got it.
Okay. Have you seen that? Do you want to see it?
I believe Mr. Gardner had made an offer, but since Lorenzo had just gotten out of treatment on April 21st, I haven't really had a chance to sit down with him and talk about his counter offer.
Okay. Well, I can give you 2 or 3 weeks if you want that. Can you get in to see your attorney or make arrangements to talk with her if I give you 3 weeks? All right. Would you put, and then run a copy and put it one in each? Okay. Thank you. All right. So we're looking at the 24th of May. How about at 1 o'clock? All right, Mr. Martin. Be sure that you make arrangements to talk to your attorney between now and then, and we'll see you back here at 1 o'clock on May 24th, okay? Thank you. Andres Curry. All right. First thing I want to do, Mr. Curry, before I get sidetracked, is ask you if you'll give me your new address, because the last couple things we've sent have come back.
Oh, what you got on it, sir?
Walnut Street, Horse Cave.
P.O. Box.
Hit me.
P.O. Box 485, Horse Cave, Kentucky.
P.O. Box 485. Horse Cave, KY. All right. That makes sense. Okay. What do we think?
Your Honor, that is correct. I do have an offer on the cases. However, today is the first day I've actually been able to meet Mr. Curry in person
There was one that got co-voided.
That's what I thought, but I wasn't 100% sure.
I can't remember. I can't remember when it was, but we did have a trial date at one time.
And I believe that's just on the older case, correct? There's no trial date.
There's a trial date on the trafficking case. I don't know if it's on the trafficking. Should the trafficking.
Yeah, the trafficking case was older, and we had a trial date set in November of 2020.
I don't have any objections necessarily because I have a good contact number for Mr. Curry and I think that he'll be in contact with me. I don't have objections to resetting the trial date. If the court wishes to do that at this time.
I'd like for us to try to negotiate.
Well, we might not, I mean, if you thought you could talk to him in the next 3 or 4 weeks, we could just kind of turn it around. It's probably not going to make a ton of difference date wise.
I think I can talk to him in the next few weeks. I know the court's aware that I'm at the trial starting next Monday, so next Monday will be kind of difficult. But
Yeah.
if you could put it at least 3 weeks out, then I think I can, I'm fairly certain that I can get with Mr. Curry.
May 24th? May 24th. I'm going to look and see just while I'm sitting here thinking about it, if we've got. Yeah, no, not really. All right, Mr. Curry. So as long as you guys are able to talk, we'll see you on May 24th at 1 o'clock. Okay.
Say it again, sir.
May 24th at 1 o'clock. Carly Key. Is that you too? I can't. You happen to have all these ones right in a row. Yes, sir. Done a good job of getting your people here, I guess.
Judge Zeta was taking the case over Josh. And I don't think she's had extensive conversations with Mr. Key.
I've been able to talk to Mr. Keith. I've got some paperwork, some documents he was going to give to me, and he didn't have those today. I was going to ask the court if we could set this over maybe in June, just so that we can, some of the paperwork I think is out of Indiana. So I'd like to get that so that I can show the prosecutor what the information is.
Yeah. Technically, we have him scheduled for trial later this month, but that one case that you'd be out anyway because it conflicts with a previous trial that you had, I think. And then the case that Greg and Risa have that's going to take all that time, it's got a child victim in it and it's going to consume all of our time. So we were going to have to pass it anyway. So I don't care to put this over. I don't mind putting this over to something like June the 14th or so, if that would do it.
June 14th works. June 14th works okay for you, Carly? Okay. I'm gonna give you my card. Okay.
All right, Mr. Key. So sounds like you're in the middle of getting some things for your lawyer. Just stay in contact with her, okay? All right, are we good? Do you have any questions? Okay. All right, fair enough. Thank you. That's Jeffrey Anderson.
Yes, sir.
Are you on here somewhere?
Yeah, I'm on the Zoom, Your Honor. When I got out of jail, they had gave me a meeting. I wasn't aware until earlier this morning when I called the courthouse that y'all were doing it in person. So she gave me a link to get in this Zoom meeting.
Oh, this is you, Moto G.
Yes, sir.
Okay, no wonder I didn't know because it doesn't have your name on it. All right, I'm with you. Yeah, I mean, he just got out within the last month, so so he can what do you want? Do you want me to get a number from him? And Mr. Anderson, can you give us a number where your attorney can call you when he gets a minute?
Yes, sir. Can you ask him? I had left my phone at the house. I'm up here trying to purchase a car right now. If he's gonna call in the next 10, 15 minutes, I can give him the phone number to the phone I'm using now. If not, I can give him my phone number, but I'll have to wait until I get back to the house to be able to answer the phone.
He's gonna be tied up with me for the next 10 or 15 minutes, so it'll probably be on an ensuing day that he calls you.
All right, yeah, I can give you a phone number right now.
All right, fire away.
270-308-8995.
8995.
Yes, sir.
Okay. All right, Mr. Anderson, let's do this then. We're going to put it off for a minute so that your attorney has a chance to call you and discuss the case with you, because I don't think you all have had much of a chance to talk. When would you like to, Greg, when would you want me to move that to? Yeah. Well, 4 weeks will be Memorial Day. I'll do 5. How about that? June 7th.
June 7th?
Yes.
Okay. Yes, sir. That works for me.
And that'll be at 1 o'clock. Now you can come in person on that day. Okay.
Yes, sir.
Sure. Yeah. Mr. Anderson, be sure you contact your attorney. If you don't hear from him in the next little bit, or if he does call you, be sure you call him back. Okay.
Yes, sir. Yes, sir. I'll make sure I do.
I want to make sure that you talk to him. That is already a condition of your pretrial release, is that you stay in contact with your attorney. So let's just be sure we do that. Okay.
Yes, sir.
All right. See you in June.
Yes, sir. See you. Have a good day.
I like this.
Yeah. He called this morning and said he didn't have a ride, and Crystal gave him what for. And he said, that's all well and good, but I still don't have a ride. And then he said, if you'll give me the Zoom link, I'll get on. I'm planning on entering that guilty plea. And we gave him the Zoom link, but he's not on.
Judge, I'm having some real issues with Mr. Wilson's got a long history of drug use. I'm constant statement. He's trying to put this off. It's going to be more his fault at this point.
Starting to look a little hinky, isn't it? Well, I tell you what, since we're going to be on here for a minute, let's just wait and see if he ever shows up. And then if he doesn't, he's popped in a little late, a time or two, but it is a little frustrating, but I believe that, he signed all the paperwork before. You remember we went halfway through we got all the way to the end of the plea. And then he said he was just a little nervous about it because he thought something about his parents were trying to make him, or his family was trying to make him go to long-term rehab or something. And we were like, that has nothing to do with this plea. And he said, well, he wanted to talk to you. Yeah. Yeah. I've got his signed plea documents in here. But when,
That's why I was wondering what he was doing, because everything was lined out there.
but then when he called this morning and he said that he couldn't get here, but he was planning on getting on the Zoom call and entering the guilty plea today. So maybe he'll show up. If he doesn't, then, I shall take a step. Sarah Whitcraft. Hart County Jail heard from. All right, everybody. What do we think?
John Duff has now been with
$524. All right, Ms. Whitcraft, be sure that you are making yourself available for conversations with your lawyer between now and then, okay? All right, thank you. Hey, I got Hart County Jail just chimed in here. I don't remember who all is involved with them. Mr. Kinslow.
Yes, sir.
I was just trying to see if they were ready to talk about your case since you all just popped in here.
Your Honor, in this case, Xander shared some information with you. They emailed that to Nova. Yeah, the lease agreement, sent in, I got that today. The email mentions receipt regarding the firearm as well.
Yeah.
That wasn't attached.
Oh, I'll have to go back there and fix that, but
I've got the lease.
I'll try to send you the receipt from the owner of the DC purchased the firearm.
Right, I don't think
A
I have.
letter confirming that the input did not reside here and the lease is not on the lease.
I don't think I've got it.
I can repeat it. I just didn't do all the attachments. Sorry. I was
No,
probably-
I didn't get the lease attachment. I emailed you about that. You sent that. But I don't think I've got the receipt or the letter as well.
Yeah, there's a receipt for the purchase of the firearm from the pawn shop too, that was purchased by Seminary.
Let me just double check those things and then I'll, give some additional time to consider that. I can put it on 2 weeks if you want to. I can go longer than that.
I'm okay with, she won't, 1 week won't help you. 2 weeks probably won't help you because the 1 week you'll be all tied up in your trial. So, you won't really be able to.
Tied up in trial, but I think I'm all kind of in court right now anyway, so if he wants like 2 weeks to, if I get a response back. I can-
Well, but you have to send him something, right, that he didn't get.
Maybe.
He's in Hart County and I don't know that they allow me to do weekend jail visits, so it might be better to do it the 24th.
Yeah.
On the safe side.
Hey, Mr. Kinslow,
Good morning, sir, or good afternoon.
it's morning somewhere. When, do you know whether there's times that your attorney's not able to come see you? Like, do they let him come on weekends or is it just like during the week?
Whenever.
Yeah.
They said whenever.
Does she have to call ahead?
Just said, no.
No, just show up.
Really?
Yeah.
Phew. That's about as easy as it gets right there.
Yes,
Except
sir.
drive up there. That's the only thing. Yeah. 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 It's not that awful far, is it?
No.
All right. Well, you want to go the 24th. I'm fine with that or the,
We might figure out how to go the 24th, just to make sure Johnson gets sent back. And I'll check the email, see all the attachments.
apparently, she has sent some things to the Commonwealth, and then a couple of things she tried to send as attachments. They didn't go, or he couldn't read them. So she's got to get that back to him. And she's got a trial coming up, and we're going to put it off 3 weeks, but all this is probably going to be taken care of before that. But just to be on the safe side, so we don't get everybody all riled up and then not be able to do anything, we're going to put it off till May 24th. Okay.
Thank you, sir. I appreciate y'all's time.
All right. And then we'll see you back here on May 24th.
Yes, sir. Same time?
Okay. Yeah, 1 o'clock. Yeah.
Okay, thank you, sir.
You bet. Thanks. Well, there's Travis right there.
Yeah, I've been trying to get logged into this Zoom.
What
I was
happened?
about to just call the clerk's office again and figure it out that way. I can't never figure it out. Like, it'll join, but there won't be no participants. It's like I'm just sitting there. I sit there for like 10, 15, 20 minutes probably.
Well, you're in here now. I reckon that's
Yes,
what
sir.
counts. All right. So, Travis, what do you have in mind today?
Well, sir, I've tried to get a hold of Greg Berry since the last court date, and I've been calling him pretty persistently, you know what I'm saying? And every time I called the public defender's office, they say he's not there or whatever. So I give him an email where he can contact me at, and I haven't received no emails about a deal or whatever. But I mean, I was just going to go ahead and agree with your deal. That way I could just get this out of the way. Because it seems like a fair deal.
Huh?
I said it seems like a fair deal, sir. I thought about it.
Yeah, I mean, I think it's a fair deal, which is what we talked about the last time. The only thing that I think you had some kind of question about whether or not there was something sneaky going on behind the scenes. And that was what I told you could probably talk to Greg about, because he could confirm to you that, his family wasn't putting him up to getting you to agree to any, your family wasn't putting him up to getting you to agree to anything. I mean, as far as I know, they hadn't been putting the Commonwealth up to anything either.
I mean, it wasn't that, sir. It's just my stimulus checks. They've all come up missing or went to some other person. And like, I could have used that money, it could have helped me out a lot. I mean, getting out of prison, and I was just frustrated.
I mean, I don't know if I can speak for these other guys, but I don't believe that they know anything about your stimulus checks either. I know I don't.
Oh yeah, I'm not saying you do. I was just kind of explaining the situation to you a little bit.
Yeah. Well, I mean, I think you might have a beef with somebody, but I don't think it affects this case or what's going on in this case is what I'm driving at.
Right. I understand, sir.
All right. Well, can you raise your right hand then? All right. Do you swear or affirm you'll tell me the truth, so help you God?
Yes, sir.
Okay. We went through all this before, but just to be safe, we need to go through it again. So, and you don't have to keep your hand up. You can put it back down. This is your motion to enter a guilty plea. Can you see that?
Yes, sir.
And this is the signature page. Well, it fell over on me. Can you see that?
Yes, sir.
Is that your signature?
Yes, sir.
Then over here on the offer, same kind of deal. That's the offer.
3 years.
Yeah.
That's me, sir.
And then is this your signature?
Yes, sir.
Okay. So when I talked to you a couple weeks ago, or whenever it was, a week back, or 2 or 3 weeks ago, whenever it was, you went through here and told me that you had read all that and you understood it, and you were okay with it. Is that still the case?
Yeah, I'm okay with it. I'm
Okay.
ready to, yeah. Yes, sir.
And you don't feel like I'm making you plead guilty, right?
No.
Do you feel like anybody else is making you plead guilty?
No, sir.
All right. Are you under the influence of anything?
No, sir.
Do you feel like your judgment is impaired or faulty for any reason?
No, sir.
Okay. Do you understand that you waive the following rights. If you plead guilty, you waive the right not to incriminate yourself, the right to a jury trial where the Commonwealth has to prove guilt beyond a reasonable doubt, the right to confront and cross-examine the people that put evidence on against you, the right to put evidence on in your own defense, and the right to appeal.
Yes, sir. I understand.
Okay, fair enough. So the offer in this case is promoting contraband first degree. Commonwealth would recommend a 3-year sentence. Drug paraphernalia, the Commonwealth would recommend 12 months. Public intoxication, the Commonwealth would recommend 90 days. Persistent felony offender in the first degree, the Commonwealth would agree to dismiss. The total recommended sentence would be 3 years. The Commonwealth would agree to probate that 3-year sentence for a period of 3 years on the condition that you are supervised by probation and parole, and that at probation and parole's instigation, I guess I would say, that you would get an assessment, a substance abuse assessment, to see if there was going to be any treatment recommendation. Do you understand that that is what the Commonwealth's offering?
Yes, sir.
And is that what you are agreeing to today?
Yes, sir.
Mr. Wilson, do you feel like you've been promised anything other than what you and I have just discussed to try to get you to plead guilty?
No, sir.
Do you feel like anybody's threatened you to make you plead guilty?
No, sir.
All right. Are you pleading guilty voluntarily today?
Yes, sir.
Do you acknowledge to me that on August 6th, 2020, in Barron County, Kentucky, you knowingly and unlawfully possessed drug paraphernalia?
Yes, sir.
That you appeared in a public place manifestly under the influence of a controlled substance to the extent that you were endangering yourself or other people, or unreasonably annoying other people in your vicinity?
Yes, sir.
And that you, with respect to the promoting contraband, that you knowingly introduced dangerous contraband, which was a syringe, into the jail?
Yes, sir.
All right. Then, Mr. Wilson, I'm going to accept your guilty plea here today as having been entered into freely, knowingly, intelligently, and voluntarily. Another question. Are you on parole?
No, I served that out.
You served it out, right?
Yes, sir.
All right. When did you serve that out? Can you tell me?
February the 8th. I'm pretty sure.
February the 8th. Okay. I guess I have to defer to the officers over here. I guess, would you all feel better about doing a PSI before we sentence him, or would you be okay with you'd rather get a PSI? Well, I know, but I mean, what would make you happy?
He's out of custody?
Yes, he's out of custody. He served out on his case back about 3 months ago, 2.5 months ago. Yeah, that's probably better. All right, Travis, look here. Here's what we're going to do. I'm going to accept your guilty plea. I've got to have you go meet with probation and parole and discuss your pre-sentence investigation. They'll prepare a report. We'll come back and sentence you on the day that we decide. And as long as everything's, nothing happens between now and then, everything's going to be just exactly like we're talking about. But it's just kind of a statutory step that they want us to go through. So how about I have you come back on June 21st, I think is what we've been saying. That's about 6-7 weeks from now. That's enough time. All right.
So I'll be will it be on Zoom or will it be in regular court?
Yeah, hold on a sec and I'll tell you. Oh yeah, they can drug test him if they have to. Yeah, I've got to get you to where you can come over here and report to their office in person. And I don't know, I know you were having some trouble with a ride, but I need to get you over here as quickly as you can. Can you get over here tomorrow?
Glasgow.
Yes.
I can try, sir. I mean, I'm not gonna sit and lie to you. Past couple weeks to a month, it's been a struggle for me to just keep a phone turned on, you know what I mean?
Yeah.
But, I mean, I can try to. Would I need to come to the courthouse?
No, you have to go to the probation office
Okay,
because they have to do this pre-sentence investigation. They have to sit down with you and, you know, get some information from you.
that's all right. I'll
All
try
right.
my best, sir.
What time can you get there?
I don't know. Like I said, I'm gonna call my mom and ask a few people if they can give me a ride over there, just being honest with you. I mean, I live with my girlfriend in Edmonton, and we don't have a car right now. She wrecked it a while back.
All right. Well, you're going to have to find somebody that'll tote you over here, okay? You went on mute there. Can't hear you.
Can you still hear me? I had an incoming call.
Yeah,
bad.
I can hear you now. Yeah. Yeah, just get over here, you know, sometime before lunchtime,
Okay.
before 12 o'clock. Okay.
Yes, sir.
All right. And then we'll put the final sentencing on June 21st at 10 a.m.
Okay.
And that we're going to do that, you know, by that time, we're going to try to be doing everything we can in person. Okay. So I want you to be here. Just works better.
I need to be at the probation office at 12 o'clock tomorrow.
Yeah. Before 12 o'clock.
Okay. What if I can't make it? I mean, or what?
Well, I guess we'll cross that bridge when we get there, but you need to try to get, you need to pull all the strings you got. Okay.
I'm trying to do the right thing. I really am.
Do what?
I'm struggling. I said, I'm trying to do the right thing. I'm just struggling a little bit.
I know, but I mean, surely you can find somebody that can run you over here, can't you?
Man, it's been hard to get a ride to the grocery store or anything. I mean, I'm not dealing with my mom or none of them. It's just, like I said, my stimulus checks are gone. I don't really have nothing right now, but I walk if I have to.
Well, I hope it doesn't come to that, but you need to get over here if there's any possible way, and you can give them a call if you're going to be running late or something like that. And, just put the effort in. Okay.
I will, sir. Thank you.
Hey, if you'll give us your phone number, maybe they can deal with you on the phone a little bit.
270-576-2494.
All right. Got you. Thank you.
Thank you, sir.
Okay. We'll see you.
See you.
Rock Kearney. All right. Mr. Barry, do we know anything? That's a bad question. With respect to Mr. Kearney?
I just gave him this discovery.
Okay.
If we could put him off, in 5 weeks, and we put the last one.
Yeah, that works. June 7th. Can you do that, Mr. Kearney?
He gave me a good phone number to get in touch with.
Yeah, June 7th at 1 o'clock. All right. Be sure that you're available to talk to Mr. Barry when he needs you. Okay. All right. Thank you. Garrison Graves. Yes, ma'am. Oh, there he is right there.
So this is one that, Mr. Drake, correct me if I'm wrong, I believe we need a trial date on. There is some additional testing that needs to be done that KSP hasn't sent off yet. They're going to do that this week. Hopefully, I just spoke with the trooper. So I guess what I'm saying is if we have a trial date next year, beginning of next year, that would be with DNA analysis, and how long that takes.
All right, I could probably do, what would you think, like maybe 3 days would be sufficient?
I think that'd probably be more than sufficient.
Yeah.
I think
Okay.
it'd probably be two.
I wouldn't think it would take 3 days.
Okay. Well, we could do March 9 and 10. It's about the best I could do for now.
I don't have anything to do that day so far.
Huh?
I don't have anything to do that day so far.
I wish I could say the same, but I'm
We know that the
I'm bumping a civil trial to put it on there. They're all going to be real happy with me. If they don't settle it, I guess it's their own fault. All right. So, and then we can set it for a pretrial. I'd like to do maybe at least the first part of February, if not towards the end of January.
Judge, would you care to maybe schedule a pretrial, like in October, October this year, so?
Yeah, that's fine.
Check on the status of that.
That's fine too. October, you want to do 25th? At 1 o'clock? All right. Clarence Allen. All right, folks.
Your Honor, he is entered a plea in Warren County case. Tracked position, and I think you've got an offer in this case to resolve. I don't know if you've had the chance to speak with him yet about that.
No, I haven't. Mr. Allen was recently transferred to me. I've been able to give him a copy of his discovery, but we've not been able to go over any detail and all the things as of yet. So I was gonna ask for a little additional time to try to do that. I do have a working phone number for him now, or an accurate phone number for him now, so.
given him an offer, to get him moving. So, that, I have.
Okay.
Enter this plea, I can pull it up on ordinance, take a look. I don't know if you can sentenced on that or not. If you could sentence.
Yes, well,
Nick Warren.
yeah, and I gotta do that grade,
That was
common sense.
June 7th.
That'd be fine, Your Honor.
He's got this other case too that I know it's just been around forever. This 01 CR 132 where he owes some restitution, and I don't even really remember. Did you hit a toll plaza? Is that what you did? Yeah. Ran through a toll plaza over there. He only owes $46,500 worth of restitution. Ought to be able to knock that out between now and when I see you again, shouldn't you? So, I mean, I'm not making light of it, but I mean, what are you gonna do? That's a lot of money. So I mean, I always just keep that going because I'm like to try to get him to pay a little something. He hasn't been real good about paying, but he's been kind of in and out of jail a bunch.
They say, the money on the black box. 2 months ago, I put the money in the ID, and they still sitting from it, I still haven't even got an ID.
Oh,
And I paid cash, I put in the black box. I haven't heard nothing from them.
so you were a little leery about putting money in that box. Yeah.
I had money today, they own my restitution and everything, I can't go down. They said the only person go down there is seem to be able
Right.
to check the safe.
Right. Okay. Well, I'm going to just run that along with this other one and we'll put them both on and we'll see if maybe there's been a break into action since then. Okay. June 7th. Be sure you're available to talk to your lawyer. Okay. All right. All right. See you.
Thank you.
Lord. Orlando Castillo. All right. What we say?
We really haven't had any discussions at all about this. And then I'm sent an offer. I assume you're just getting in on this.
I had assumed that an offer had been made before I took over the case, but my notes were showing that the case was always under trial.
Yeah, that's correct. I did send an offer.
Do you see an offer in the file?
Oh yeah, you're not wrong.
But I was under the impression that
I think I had lost sight of those being set for trial. You're focusing on the harm and this, that, but
Yeah, it is. It is set for June 2nd. So give me just a second here to figure out what's. It's probably what I need to do is for all of those trials that are set in the first couple of weeks of June, we've got our a final pretrial date, which we don't have all the pretrials in there, but we got a final pretrial date for June the 1st. You know, because they want you to have a pretrial within like 48 hours or whatever. I can't remember, 72 hours, whatever it is. So because you have that holiday in there. So we have a final pretrial date of June the 1st for anything that we're going to have set for trial over that next little bit. So I think that if you want to put this over there to June the 1st and just see if y'all have a way to talk about it before then. They'll be at 1 o'clock.
Is it, I hate to ask this, but it looks like a lot of cases are set on top of each other. Will we know which one's gonna be first in advance, or will they, do I just need to write for everything that I said?
Well, I'm hoping that they know which ones are kind of burning a hole in their pocket, and they can communicate with you all which ones those are going to be before we do it. I didn't have any way to really do that because they want all these pretrials to be shoved in there so close to the trial, which I'm not real sure what the theory of that is. I know what the theory is. I don't think it really works, but because otherwise I don't know how else to have you all notified of what they plan on trying.
Judge, speaking of that, we've currently sat down and gone through everything, talked about it. If Sandy and Greg want to set up a Zoom meeting or something, we can discuss what we talked about.
Yeah, I think that would be good because obviously you can't really get ready for everything. But you know, these are desperate times.
Okay, because I'm looking on CourtNet just to see what cases are set for trial that day, and there's only 2. This one's not listed on CourtNet.
It is possible that whichever clerk put that in, and it wasn't this clerk, put it in on 2020 instead of on 2021. But what I wrote was June 2nd, 2021. So that's what we would have said in court. But it's possible that if it's not showing up, it's because it accidentally got put in on 2020 instead of 2021.
That's correct.
Yeah.
I just did it. And that's what's in front.
Because that happened a few different other times. Yeah. So we might ought to zap down there to 2020 and see if that happened on any other
I'm only
cases.
showing 2 others on that date. Yes. And Jason, though.
Yeah, I certainly lost track of how many we set, but I don't think we set hundreds, but I think we set 4 or 5. And then I think that next week we also set 4 or 5, just figuring that we were going to be able to try something.
That's the one I think we talked about.
4.
Yeah.
Okay.
But I definitely think it's something that you all could just all kind of get together on a conference call or something and figure it out. You know, we don't normally, this is kind of new ground for everybody because I've never liked to set multiple trials at one time like a lot of places do. And so this is a new experience for, they're not used to me doing that either. Desperate times call for desperate measures though.
Yeah, we'll just talk. It sounds like, but I guess it's gonna take priority on that day.
That's what we talked about.
Yeah. So there's another one that's gonna take priority now.
But we also have that whole week. So, we have 3 days that week and 4 days the next week.
Yeah.
Or it may be 3 and 3 because it's a second Tuesday. It's a second Tuesday. So, we could conceivably be able to try more than one case each week. Okay, so let's put this over to June 1st at 1 o'clock. And
1 o'clock, Your Honor.
yes, ma'am. I'll be honest with you, I can't remember whether we did 1:30 or 1 o'clock. So if it's 1:30, it's fine.
But it doesn't matter. I just want to make sure that he's got the right leader, right time.
Yeah. I can't remember whether we had set all those at 1:30 or 1 o'clock, but in any event, if he gets here at 1, he'll be fine. All right. Thank you. Headley Johnson. All right. What do you say, everybody? Yes, we did.
We could try, I guess we go on until we just reset a trial date at this point, or reset a pre-trial maybe. And then see, if we're still at the point, it's just gonna be a trial.
I would like the second option to see, where we are. I don't remember us having real in-depth conversations about resolving this case.
We talked a couple of times, but it was.
But we set a pre-trial conference during that talk again. And possibly talk about how we can move forward with this case.
I can live with that. Y'all just tell me a day.
That's it.
All right. You want to do June the 7th? All right, June 7th, 1 o'clock. Ben Duval? I would definitely think that the only way we would have to do it is if he was going to ever enter any kind of plea, because I think he understands pretty much everything that I'm saying to him. He doesn't speak quite as clear, he doesn't make himself understood all that well, but he understands everything that we're saying to him because, he's always here and he's always, but we can probably try to have the interpreter. It's just that that guy's tough to line up. Yes.
I think Mr. Barry, talk to him, send the scholar. Greg, want to talk to him now and see if he can work it out? I'm sorry, you want to talk to him now and see if we can work it out, or you need more time?
Do you have a certificate or anything like that where you?
I've been in rehab about 10 months, and yeah, I got certificates for them. And I was gonna stay longer, but my mom died, and my grandmother died, and my grandfather, all in about 6 months.
Oh, shoot.
And I've been in a depression, man. It's been bad.
Yeah.
But yeah, that's why I didn't go to, further with it. But you need those?
Well, I think you might want Greg to see them, and then he can show them. He can,
Yeah, I've got two of them.
I knew you went back in the fall, and we're planning on being there a while. So
My brother, he's in, doing really pretty good too. Yeah, my mom hadn't died, I was kept going, man. It's just I had it. There wasn't nobody else.
yeah.
You lost my whole family there about 6 months.
Well,
crazy.
Yeah, I hate to hear that.
Not too long, Judge. I made an offer of probation in this case. He's the last of 4 co-defendants. I'd like to try to resolve it together if they want to encounter, all ears.
Okay. Do you think maybe a couple weeks, Greg, would work?
After the 3 weeks.
Yeah.
So much on
24. So, Mr. Duval, it sounds like there's an offer on the table. You and Mr. Berry just need to be able to carve out a few minutes to talk about it. So be sure you kind of cooperate with him to get something done, okay? All right. You bet. Sam Wheeler? I don't know. He was a Josh case, so I don't know who got him. Did Greg get him? Samuel Wheeler? Mr. Wheeler, can you tell me your address? 85 Old Mill. Okay. So, Mr. Berry, what do you think? I mean, I could do, give you till June 7th on this one. I think it's, again, looking at the charge, it's probably one that you'll know fairly soon, pretty quick, whether it's doable. All right. So, Mr. Wheeler, we'll see you then, okay? Mr. Busey. Charles Jr.
Joe, just so you know what this matters, I think it's just, Josh was his original attorney. We had to talk about this case a little bit, but related offers, I'm not sure if we ever, I think you met with Mr. Busey, but I'm not sure if we accepted or not.
If you don't, I'd like to try to meet with Mr. Busey sometime this week, just to go over the offer and do paperwork if he wishes to accept that offer. I have the offer, I have the discovery, but we just need a little time to actually go over what all this entails with the offer. So I'm happy to, if the court was to set it back over for the 17th of May, I should have met with him by then.
All right, we can do it. It's 2 weeks. So just, do you want to tie him down to a time before he leaves, or are you just going to call him or what? All right, fair enough. Be on the lookout. Okay, thank you. All right, everybody. We are probably about ready to get the jail up and running, but I tell you what. I'm going to take a brief respite before I do that. 5 minutes or so. One thing I want to try to do, see how much play I've got in this, if I can get it up here. Because the closer it gets over here, the better off we are. Can how to make that fill up the whole screen. Don't you think that'd be more helpful like that? But I've got it as big as I can get it. Do what? What now?
Them looking at it like this.
Yeah.
Come around.
Oh, that's, yeah. How'd you do that?
Click that button right there.
With your mouse? Okay.
I wish they make a touch screen.
Yeah, I thought it was touch screen. See, I couldn't get it done. Yeah, I mean, I think this is gonna have to do. So. All right.
Hey, Judge, you come back, you want to go straight to the jail, or did you get Philly deal? Judge Pat.
I didn't know we had a deal. Just let me,
Okay.
Are you ready to go?
Me?
Yes.
Yeah.
All right.
I did not. It just said the host would like you to unmute. I was like, it's never said that before.
Oh, well, we got all kind of fancy tricks up here. All right. It looks like, let's see. Looks like I've got some paperwork here that I need to talk to you about.
Yes, sir.
Before I do that, can you raise your right hand? Do you swear to tell me the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, thank you. So, Mr. Neal, this is a motion to enter a guilty plea. It's got your name and your case number on it. And if you go over here to the second page, it should have your signature on it. Is that your signature?
Yes, sir.
All right. This is the Commonwealth's offer on a plea of guilty. It should have your name and case number and so forth on it. And if you get down here to the second page, it should also have your signature on it. Is that your signature?
Yes, sir.
Okay. Did you go over both of these things before you signed them?
Yes, sir.
Did you make sure that you understood what you were signing?
Yes, sir.
Did you have the opportunity? Oh, go ahead.
And on the paper, it says the $1,000 fine and the restitution. What about that? I mean, my attorney told me not to worry about it.
Well, the fine is something that just anytime you're found guilty of a felony, you can get a fine, but it's discretionary with the court, whether to waive it or based upon, like financial circumstances or whatever. So the fine is something that the Commonwealth is recommending, but it may or may not happen. The restitution is, I don't know that there will be any restitution because it says to be determined. So, what we'll do when we walk out of here is that I will give them, a certain amount of time to see if they can prove any restitution. If they can, they'll get back to your attorney and talk with her about it, and we'll either have a hearing to decide it or there won't be any.
Okay.
Or you all will reach an agreement on it. One of those three things.
Okay.
Because I don't know anything about whether there will be restitution or not.
Yes, sir.
Okay.
Yes, sir.
Did that help?
Yes, sir.
It wasn't a real firm answer, but it's best I can do.
Yeah. I mean, that's all you can tell me.
All right. So, aside from those questions, was there anything about these two documents that you couldn't understand or that you couldn't get an explanation for?
No.
All right. Do you understand that you do not have to plead guilty? And if you decide to plead guilty, that is your decision to make voluntarily and of your own free will?
Yes.
All right. Do you feel like you have been forced by me or anyone else to plead guilty today?
No, sir.
All right. Do you understand that you have the right not to incriminate yourself? And if you plead guilty, you waive that right?
Yes, sir.
You have the right to a jury trial where the Commonwealth has to prove guilt beyond a reasonable doubt.
Yes, sir.
You can confront and cross-examine the people that testify against you, and you can put evidence on in your own defense. You
Yes,
understand
sir.
that you waive those rights if you plead guilty.
Yes, sir.
You understand that you waive the right to appeal if you plead guilty.
Yes, sir.
All right, sir. Mr. Neal, do you feel like you're under the influence of anything right now?
No, sir.
Is your judgment impaired for any reason?
No, sir.
Are you having any trouble hearing me or understanding me?
No, sir.
All right, thank you. In this case, the Commonwealth is making the following recommendation. On a plea of guilty to count one, theft by unlawful taking or disposition, $10,000 or more, that is a Class C felony. The Commonwealth is recommending a sentence of 5 years. Count two and count three, each of which is burglary in the third degree, a Class D felony. The Commonwealth is recommending a sentence of 4 years on each, all to run concurrently for a total recommended sentence of 5 years. The Commonwealth also, as we talked about a minute ago, would recommend a fine of $1,000 in court costs, restitution which would be joint and several restitution with your co-defendants if there is any restitution, and both the fact of restitution and the amount of restitution is to be determined, it says. The Commonwealth opposes probation or shock probation, and a condition of the plea is for you to have no contact or communication with the victim or victims and the family thereof. This sentence would be consecutive to any other sentence that you may have.
You're on mute. You're on mute, Judge.
That's my line. What part did you not hear? What part did you hear?
You was talking about not to have any contact with the family of, and then after that, and then on mute.
Yeah, a condition of the plea is that you would not have any contact, direct or indirect, with the family of the victim or with the victim himself or herself, and that this sentence would run consecutive to any other sentence that you might, already have. Is this what you understood your offer to be?
Yes.
All right. Do you believe that anybody has promised you anything other than what you and I have just talked about to try to get you to plead guilty?
No.
Has anyone threatened you to try to make you plead guilty against your will?
No.
All right. Are you telling me here today, Mr. Neal, that you are pleading guilty voluntarily?
Yes.
Are you acknowledging to me that over a period of time from June 18th to June 29th in the year 2020 and occurring in Barron County, Kentucky, you unlawfully took or exercised control over movable property of another person or people valued at $10,000 or more, but under $1 million, with the intent to deprive the lawful owner or owners of the property?
Yes.
All right. Are you further acknowledging that over that same period of time, and again in Barron County, Kentucky, with the intent to commit a crime, you knowingly entered or remained unlawfully in a building belonging to another person or persons?
Yes.
All right. And that occurred on two separate occasions, which is why there are two burglary and the third degree charges. Is that correct?
Yes.
Okay. All right, Mr. Neal, then what I'm going to do is accept your plea of guilty today as having been entered into freely, knowingly, intelligently, and voluntarily. I believe that this will be one that everybody's going to want to do a final sentencing on. So I'm going to set you a final sentencing date for, we might ought to do June 28th. You'll be around June 28th. Be around June 20th. All right, June 28th at 10 o'clock a.m.
Is that in person or on Zoom?
No, that'll need to be in person, okay?
All right.
All right, here's the other thing. I'm going to need you to make some arrangements, and in a minute, we'll talk about the details. I'm going to need you to make some arrangements to come and meet with the probation officers that are here in Barron County so that they can prepare what we call a pre-sentence investigation report for us all to take into consideration at your sentencing. So do y'all just want me to get a number from him, or do you want to set up a specific time? Can you tell me a phone number where they'll be able to reach you, say tomorrow or this afternoon?
270-576-6317.
Did you get it? All right. So they're going to be calling you, and they'll set up an appointment for you to come in and meet with them. Okay.
Okay.
All right. Do you have any questions?
No.
All right. So just when they call you, just do what they tell you to do. Come in, meet with them like you're supposed to, and then we'll see you back here on June the 28th, and that'll be at 10 o'clock in the morning. Okay.
All righty.
All right. And you're still on bond in between now and then, so don't get in any trouble, and have things go south on you.
I'm staying out of trouble. I'm working and I get my drug test and stuff, so I pass
Okay.
all that.
All right, keep it up, okay?
All right.
All right, thank you.
All right. Have a good day.
See you. Y'all wanna, it kind of slipped my mind that Johnny had a few, and he said he was gonna have them in his office. Do you wanna try to do those real fast?
I'm here, Judge. I've got Caleb Calhoun. Hey, Caleb.
So whenever he feels we need to put these back.
Oh, you're fine.
All right. Ms. Gardner was saying that you all are going to be getting together on some of these. So when do you want to put this?
We're gonna get together Wednesday, Judge, just whatever pleases the court.
Well, Monday'd be fine with me.
That'd be all right. Is that okay with you, Risa?
She says yes.
That'll work, Judge.
Can you hear her when she's talking?
Yes, sir.
Okay. I'm trying to get a feel for.
I got ears like a dog, though.
Yeah. Like a basset hound from this angle.
They don't flap over, but they catch a lot of racket.
It flees.
Yeah.
May the 10th.
And Judge, we're doing the same thing with James Houchins. If you want to do the same thing, deal with that.
Well, is he on your list of topics? All right.
Yes, sir.
All right. So that's a 5:10 at 1 o'clock.
Yes, sir.
All right.
The only other thing I've got is Kyle Gardner, and he's in jail, Judge.
Oh. Okie dokie. Well, I think we can probably get him.
Okay.
Bonnie, can we get Mr. Gardner? They've been waiting for us so long, we had to send up a signal flare to get their attention.
Just a second to get in, Judge. Can I get Kyle Gardner for court?
Your mercy. Oh, hey, Johnny.
Yes, sir. Yes, sir.
Doing this one?
Tyler. Yeah, I can do that, Judge. I believe he's in rehab, is he not?
Nope, he's up there in the Hooscal. There he is.
I've not talked to Tyler since he went into rehab. I mean, I have, but not since I guess he's in jail there, so I will need to speak with him before. What's his, has he got a bond or?
Yeah, there was a motion to revoke bond that was filed by the Commonwealth, and we didn't take any steps on it really because he had gone to rehab, but his probation officer over in Warren County had I don't remember the whole story, but he had called over here and wanted a warrant. And so we had done a warrant for that. And then when he went into rehab, I asked him if they wanted me to recall it, and they said no. So he was in rehab for a while, but they wanted the warrant to stay active. So it, and
Yeah.
I really don't know what happened with whether he completed anything or not, but you got some time to talk to him if you want to.
Did you have time to complete that, Tyler?
Yeah. Hey, my parole officer in Warren County wasn't the one who put the warrant out on me. It was circuit court. Because they ain't even revoked my parole yet. I'm still on parole.
Well, no, I know they don't put the warrants out because a probation officer can't put it out. I'm not denying that I put it out. I'm put it out because they asked me to.
Yeah, my parole officer's Dustin Harvey in Bowling Green. I've been in contact with him. He didn't have a problem with me being out on bond. I've still been reporting him the whole time I've been out.
Well, Sometimes I'm the last guy to know.
Yeah.
But we still got this motion to revoke bond issue that has to be taken up. And I don't know what, how that's going to go. But why don't I just put this on for Monday, Johnny, since we just put those other ones on? And, maybe you can talk to him and, maybe he's got some proof of what happened and you can show that to the Commonwealth and they'll be happy. I don't know.
Who's got his case? Which person?
I think Mr. Gardner.
It's my case.
John?
We probably need to turn that because you can't see John on it. That's what the problem is.
Well, I will try to get in touch with him Wednesday when I go over there and see what we can get worked out, if that's all right with Mr. Gardner.
Okay, I will.
Call me on that, Johnny.
I got a meeting with Risa Wednesday at 9. Would you have time to talk about it then?
I should.
All right. All right. So I'll see you Monday then. We'll put it on Monday at 1.
Okay. Tyler, I'll be talking to you.
All right. I gotta go back.
And then Johnny, one other thing I wanted to ask you about. Just when you think you're out. Are you going to be involved in this case at all?
Who is that?
Gossip.
Chambers. I've not been in contact with anybody on that, Judge.
Okay. He got in a little bit of trouble last year and I think you appeared with him and we ended up putting him back into drug court so he could go to rehab and
yes, sir.
Some issues arose over the last week. And so he was on the 10 o'clock docket and nobody, he didn't know and nobody really knew whether you were going to represent him when we had this revocation hearing.
Well, if he yells at me, I'll probably do something for him.
Okay. Well, he's going to have to yell from the jail.
Well, if anybody over there sees him, tell him to call me.
All right.
In your honor, Mr. Gardner's case and Kyle Gardner's case, I did have an opportunity to go and visit with him over to the, I was able to visit with him for a good while. We had a good discussion. I have got authorization to make a counter offer in the cases. So I will do that. And, if we could put him off a couple of weeks or something or whatever, pleases the court's time schedule, we'll be able to have more information after I talk to Mr. John Gardner.
Johnny, I've looked at my schedule. I'm available that Wednesday morning as well, so this way I'll be, that day also.
Okay, that'll work.
Is it too soon to just put it back on for Monday just to see whether you all have had a chance to talk or should I do a different day?
I would say that if we talk, Judge, Monday will be a little quick because there's a lot of things to discuss.
Yeah.
We just arraigned him on a few weeks ago.
Yeah, I'll do it whenever you want to do it. I just, since we just put a bunch of things on there, I thought we could do this too, but I'm not pushing it.
If we could go out, what do you think, John, about 3 weeks or so?
That's fine. I know your office has contacted me about some digital information. I've talked to Deputy Bo about that. He's supposed to be getting that to me, so we might want to do 3 weeks just to make sure that that's not junk.
Okay.
All right. So that's the 24th at 1 o'clock. May 24th. Okay.
Yes, sir. Thank you, Judge. All right.
Hey. All right. I'm just going to run down the list here. Joshua Binge. All right, gentlemen. Yeah, that's him. Yeah, I don't know why it's locked on me.
We don't have a resolution yet. We may just come to the point we end up saying, well,
Okay. Okay. So you think maybe one more pretrial might be worth a shot before we give up? All right. You have an idea about how long you would want to do that? I know we've loaded up the last few. June something? Does that work for you? 21st and 28th are out for you, right, John? Or is it?
28th now, right? 28th, 21st, I think, right?
Oh, well, the 21st is when I'm gone. That's the day you're supposed to yell at me if I try to set anything because I'm not here. We only made it to 4 o'clock. Setting God only knows how many things on that day.
I do good keep up with my own stuff.
She can't keep up with her own stuff. What would y'all care if I went July 12th then? There is no telling how many things. You're gonna have to, we'll have to go through there and redo that. All right, we're gonna go, we're gonna put yours on July the 12th to give everybody a couple months to see if they can coalesce, and if not, we'll set a trial date, okay?
Your Honor, is there any way that we can address my bond? Can I be put on U-turn? I've taken care of my stuff out of Hart County. I know that it looks bad on paper because I caught the new case while I was out on bond for the other case, right? But I mean, technically it's innocent till proven guilty. I'm not going anywhere. I have 2 kids. I have an 8-year-old daughter and a 9-year-old son. I'm not going anywhere. And I mean, if you do this for me, it'll show you guys that I'm worth a chance at probation. You know, if not, then it just adds up more to, you know, it's working against me. I'm just asking for one chance.
I don't remember enough about it. I mean, I don't mind taking those and taking that request under advisement. I'll let the Commonwealth say what it wants to say. I just would have to go back and look at, it's been a while since I've done set any bonds on that case. So
I'm just asking for one chance to show you guys. I know you don't know nothing about me. I'm asking for a chance to show you that I'm worth the time and the effort to actually, I want to go to rehab. Like I really want to go to rehab.
I understand.
Mr. Bench stated he was charged with receiving stolen property, stolen car. He was let out of jail on bond, and the allegations are that as soon as he was let out of bond, he stole another car. I think maybe stole 2 more cars in the process. That he had 2 or 3 receiving stolen property or theft charges, went on a spree as soon as he was let out of bond. So the Commonwealth believes that he is high risk. That given a bond, it should be a large cash bond.
Yeah, I do remember the timing being kind of the big issue on the way that those charges fell down. But listen, I do not have a problem with reviewing your bonds that we've set and taking that request under advisement, and I may be able to, agree to make some changes on it. I'll just have to take a look. Okay.
I appreciate it, sir. Just to let you know, I do not have any funds available to me. I've been incarcerated now since December 23rd. waiting for this right here, this new case. I was picked up on December 23rd, and I've been sitting here this whole time waiting and trying to figure out what's going on. I'm just asking for a chance. I mean, just give me a chance. I'll show up every day if I have to. I just need to be out there to be able to work for my children. You get what I'm
I
saying?
understand. Yeah, I understand. Okay,
I appreciate it, Judge.
all right,
Thank you.
you bet. Thomas Dobson. All right, everybody. What we got?
Talk to. Okay. That's gonna be an issue. Harder cases. Take that.
Yeah, I mean, I think that's going to take the whole week.
Tyler Carter case, reason I asked you, that's the schedule to them. Doctor's going.
Yeah, I mean, you all have, what, at least two?
Well, one doctor, one is the pediatric forensic team.
Yeah. Yep. I'm assuming that, I mean, and again, what I think the idea is that anything that we've got set for trial over that period of time, we need to have it on for a pretrial right before, because there could be just some kind of miracle that occurs and, you know, Mr. McCarter comes in and says he's entering a plea on the Monday before, and then I don't want to have those 4 days set aside and us cancel a bunch of things and then not have anything to do, you know? So what I guess we need to do is put this on May the 17th, just to make sure that other case goes. And then, you know, step back and kind of reassess where we are at that point. Be open to any suggestions that you have. Not agree with them, but I'll be open to them. So we'll just move these over to May 17th at 1. And go from there. Okay.
Your Honor, is there any way that you can reinstate my bond and let me get out today?
Do what?
Is there any way that you can reinstate my bond so that I can get out today?
Well, I'm not real likely to do that. We're going to put you on for 2 weeks from now. And I mean, we'll talk about it then.
All right. Thank you, sir.
Because I don't know what's going to happen. And I mean, you know, I don't know if I'm going to be trying you that next day or not. If I'm not, then it's going to be a while, and, you know, there'll be a whole different set of factors to take into account at that point. Okay.
All right. Thank you, sir.
All right. Dustin Furlong. Yep, got it right here.
Oh,
Hello, Mr. Furlong.
Hi.
Can you raise your right hand for me? Do you swear to tell me the truth, so help you God?
yes, sir.
All right. Mr. Furlong, take a look at this. This is a motion to enter a guilty plea It's got your name on it right there. Do you see that?
Yes, sir.
Your case number. And then over here on the back is the signature page. Is that your signature?
Yes, sir.
Okay. The Commonwealth's offer. See that?
Yeah.
Does that look familiar to you?
Yep.
All right. Is that your signature?
Yes, sir.
Okay. Did you read over both of these things and discuss them with your attorney before you signed them?
Yeah, I talked to him.
Well, I mean,
I
did you,
can read.
okay, did you understand what you signed? I mean, did he explain them to you?
I just signed it. Go on, get it over with.
Well, I'm not doing that. I mean, either you know what you signed or you don't know what you signed.
Yeah.
Yeah, what?
Yeah, I know what I signed.
How do you know?
I don't. I just know I don't.
Okay. Have a seat. All right. We're going to reset that for May 24th at 1 o'clock. Hope I didn't hear what I thought I heard. I did. And I Googled him and confirmed it. I read his obituary. And I don't know if he had another injury after that or if that was all from the same. Yeah. You know, it didn't go into that much detail, but. James Brandon Keaton. He died in March. All right. Hello, Mr. Keaton.
Hello.
Mr. Keaton, it appears that I have in my hand a motion to enter a guilty plea and a written offer from the Commonwealth on a guilty plea.
Yes, sir.
Are you familiar with those documents?
Yes, sir.
Okay. Can you raise your right hand, please?
I just clocked out. Court, I've got to be in court at 1 o'clock. So, yeah. What's that?
Do you swear or affirm that you will tell me the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
All right. Thank you. Mr. Keaton, this is your motion to enter a guilty plea. Does that look familiar to you, sir?
Yes, sir.
And here is the second page of that. Is that your signature?
Yes, sir.
This is the Commonwealth's offer on a guilty plea. Does that look familiar as well?
Yes, sir.
Second page right here. Does that also bear your signature?
Yes, sir.
And did you read these documents before you signed them?
Yes, sir.
Did you have the opportunity, if you needed to ask questions about them?
Yes, sir.
Okay. Are you satisfied that you understand what you have signed?
I understand completely.
All right. Do you realize that you have a right not to incriminate yourself, and if you plead guilty, you waive that right?
Right.
You realize that you have the right to a trial by jury where the Commonwealth has to prove guilt beyond a reasonable doubt. You can have the right to confront and cross-examine witnesses and the right to put evidence on in your own defense. And you have the right to appeal. Do you understand that if you plead guilty, you waive each of those rights?
Yes, sir.
Thank you, Mr. Keaton. Do you understand that you cannot be forced or compelled to plead guilty and that any plea of guilty has to be voluntary?
Right.
Do you feel like I am making you plead guilty?
No.
Do you feel like anyone else is making you plead guilty?
No.
Thank you. Your offer is as follows. Count one, possession of a controlled substance, first degree, second or subsequent offense. Second offense. I'm sorry. Possession, first degree, second offense. That is a Class D felony. The Commonwealth agrees to recommend a sentence of 1 year. Count two, possession of drug paraphernalia, a Class A misdemeanor. The Commonwealth agrees to recommend a sentence of 12 months. The sentences would run concurrently with one another for a total recommendation of 1 year plus a possible fine and court costs. The Commonwealth opposes probation, and the 1 year sentence would be consecutive with any other prior sentence. Is that your understanding of the offer from the Commonwealth?
Yes, sir.
Okay. Other than that, has anyone promised you anything to try to induce a guilty plea from you?
No.
And has anybody made a threat of any kind to try to get you to plead guilty?
No.
Are you pleading guilty voluntarily and of your own free will?
Yes, sir.
Thank you. Do you acknowledge that on August the 7th, 2019 in Barron County, Kentucky, you knowingly and unlawfully possessed methamphetamine and drug paraphernalia?
Yes, sir.
All right. Okay. Okay. I don't know. I mean, I don't really have a huge problem with that, I don't guess. Does Ms. Gardner care?
Judge?
This is John's case.
Yeah.
So I don't think we would mind that.
Yeah.
He should remain in custody.
Sure. I think he's probably serving something, isn't he? Yeah. Go ahead, sir.
Yes, I got a serve out on my 10. I'd like to just go ahead. I'm already a state inmate, just final sentencing today.
Oh, you want to go ahead and get sentenced today?
Yes, sir.
All right. We were just talking about did you talk to your lawyer about wanting to put it off?
Yeah, but we'll just do it today if that's all right with you.
No, that's fine with me. I just don't want you to, I don't want you to think I'm leaning on you.
No, we'll get it done today if that's all right with you.
Yeah, I can live with it. All right.
Okay.
So, Mr. Keaton, anything you want to say?
Nope.
Okay. Then I will accept your plea of guilty and I will go ahead with your sentencing and sentence you to this 1 year. Your fines and your court costs will be waived. And your 1 year will be consecutive. Okay.
Yes, sir.
Do you have any questions, sir?
No, sir.
All right. Thank you.
Thank you.
I was aware because I happened to get on the jail website this morning or last night and see it.
Does he have a hold in this warrant? I'm sure we could file a motion. When I was in district court, I don't believe he had circuit court. I'm sure Ms. Parker could let us know, but he's been given an unsecured bond in the district. I'll let Judge Hamilton know that they're
I'm checking. All right. I'm checking with her. Stanley Merrill.
Merle. Talking to you here today. Merle, go up.
Oh. Yes.
How you doing, sir?
Doing all right. How are you doing?
Trying to make it.
This was originally Josh's case, so Ms. Myers just. Ms. Myers had mentioned to me that already been revoked, his probation before Judge Steve's currently a state inmate. She's, Ms. Myers was shot probation motion first before we tried to run hospital.
That's accurate, Your Honor. I met with Mr. Murrow last week. It's the first time that I've been able to meet with him. He had some major medical issues going on, and I was gonna detail that, in the shock motion. Obviously, I didn't have enough time to actually file a shock motion just yet with the court, but I plan on doing that this week. I do realize that you have these other two pending cases. Side restrictions are going on. Tell just on the video, and meeting with him in person, we have pretty substantial medical issues, and when I was there with him last week, like seeping, he's got some skin issues that you can hardly see on the video, but they're pretty severe.
Okay. All right. So how long would you like me to move this off?